over 2 million immigrants call California home. And according to recent enforcement reports and policy analysts, thousands could face new deportation risks in 2026 under updated federal priorities. But here's the shocking part. It's not just undocumented border crossers who could be affected. Some visa holders, certain green card holders, and even long-time residents with old legal issues may suddenly find themselves under renewed scrutiny. If you think this only applies to other people, you might want to think again. What's changing isn't just one law, it's a combination of expanded data sharing, stricter classifications of criminal offenses, and increased visa tracking systems. Small mistakes that once went unnoticed could now trigger serious immigration consequences. Imagine living in California for 10, 15, even 20 years, only to discover that a past paperwork error or minor charge now puts your future at risk. So, who is really affected? And how serious are these changes? Stay with me, because some of what's coming in 2026 might surprise you more than you expect. Number one, expanded data sharing between agencies. One of the most important and least talked about changes in 2026 is the expansion of data sharing between local, state, and federal agencies. Now, before you panic, California is still considered a sanctuary state that hasn't disappeared. But here's where things get serious. Certain criminal databases, booking records, and biometric information are becoming more accessible under federal enforcement partnerships tied to public safety investigations. What does that actually mean in real life? It means a minor arrest, even without a conviction, could place someone's information into systems that are reviewed at the federal level. Years ago, some of these records stayed mostly local. Today, digital systems communicate faster than ever. And once information is shared, that it's much harder to control how it's used. Imagine resolving a small legal issue and moving on with your life, only to have that same record resurface during a visa renewal or green card application review. That's the kind of ripple effect legal experts are warning about. The key word here is visibility. Authorities may not be increasing enforcement everywhere, but they are increasing access to information. And access changes everything. So, what can you do? First, understand that even minor legal matters matter more now. If you're not a US citizen, always ask, could this affect my immigration status? Before accepting any plea deal or legal agreement. Second, regularly check the accuracy of your legal and immigration records. Mistakes in databases happen, and fixing them early can prevent major stress later. This isn't about fear, but it's about awareness, because in 2026, information moves fast, and being informed might be your strongest protection. If this opened your eyes even a little, drop a comment below and tell us your thoughts. We read every single one because your voice truly matters to this community. We put a lot of time and research into every video to bring you clear, honest information. So please take just 1 second to hit subscribe. It's one simple click for you, but it helps us keep creating content that protects and empowers you. Number two, broader definition of removable offenses. Here's something many people don't realize. In immigration law, the label of a crime matters more than the punishment itself. Under updated 2026 enforcement priorities, certain offenses are being interpreted more strictly when it comes to deportation eligibility. And that's where things get complicated. You might think It was just a misdemeanor. But immigration law doesn't always see it that way. Some crimes can be classified as crimes involving moral turpitude or even fall under expanded definitions of aggravated offenses. And those classifications can trigger removal proceedings even if jail time was minimal or avoided completely. This is where many families are caught off guard. Imagine someone accepting a plea deal to quickly close a case, the thinking it's the easiest way to move forward. Fast forward a few years, they apply for citizenship or renew their green card, and suddenly that same plea becomes a red flag in their immigration file. The punishment may be over in criminal court, but immigration consequences can last much longer. What's changing in 2026 isn't necessarily the number of crimes, it's the interpretation and enforcement priority attached to them. Federal authorities are reviewing records more closely, especially for non citizens with past convictions. So, what can you do? First, never assume a minor charge is immigration safe. Always ask a defense attorney whether the plea has immigration consequences. Second, if you already have a past conviction, consider consulting an immigration attorney to review your file proactively. In some cases, the post conviction relief may be possible. The bottom line? In 2026, the difference between staying and facing removal could come down to one word in a legal document, and that's why awareness is not optional. It's essential. If this information made you think twice, tell us in the comments. Did you know minor charges could have major immigration consequences? Your experiences and questions help others learn too. We spend hours researching and breaking this down in simple terms, so please take just one click to subscribe. It truly supports the work we do and keeps these important updates coming. Number 3. Visa overstays under the microscope. Here's a surprising fact. A large percentage of undocumented immigrants in the US didn't cross the border illegally. They entered legally with a visa and simply overstayed. And in 2026, enforcement priorities are placing renewed attention on exactly that. Tourist visas, student visas, temporary work visas. These documents all come with expiration dates, and once that date passes, your legal status can quietly disappear. In the past, visa overstays didn't always receive the same level of attention as border enforcement. But today, digital tracking systems, biometric entry exit records, and interagency databases are making it much easier to flag overstays automatically. Imagine finishing college, landing a job, see building a life, and assuming you'll fix the paperwork later. That delay could now carry heavier consequences. Even a short overstay can trigger re entry bans, visa denials, or complications when adjusting status in the future. What makes this even more serious is how fast information moves. Airlines share passenger data. Entry and exit scans are logged electronically. If your authorized stay expires, the system may already know, even if you haven't received a notice. So, what can you do right now? First, check your I-94 record online and confirm your exact authorized stay period. Don't rely on memory. Second, if your visa is close to expiring, explore extension or adjustment options early, not after it's too late. And third, never assume silence means safety. In 2026, visa compliance isn't just paperwork, it's protection. And the sooner you review your status, the more control you keep over your future. If you've ever worried about visa deadlines, share your thoughts below. Your comment might help someone else avoid a costly mistake. We pour serious time and research into every video. So if this helped you even a little, please take 1 second to hit subscribe. One click from you keeps this mission alive. Number 4, worksite compliance audits are increasing. For many immigrants, work is stability. It's routine. It's normal life. But in 2026, the workplace itself is becoming a key area of immigration enforcement through expanded I-9 audits and employer compliance reviews. Here's what's happening. Federal agencies are increasing inspections of businesses to verify that every employee's work authorization documents are valid, up to date, and properly recorded. And this doesn't only affect undocumented workers, it can impact visa holders, DACA recipients, green card applicants, and even permanent residents with expired or mismatched paperwork. Imagine going to work like any other day, and suddenly HR calls you in because your employment authorization document expired last month. Maybe you filed a renewal. Maybe you assumed it was processing. But under stricter enforcement, employers are under pressure to act quickly to avoid penalties. That pressure trickles down to employees. Another issue? Simple clerical errors, a typo in your name, an incorrect document number, an outdated version of a form. These small mistakes can now trigger deeper reviews. So, what should you do? First, review your employment documents today, not next month. Check expiration dates carefully. Second, if you've submitted a renewal, keep copies of receipts and approval notices. Third, communicate proactively with your employer if your status is changing. In 2026, compliance is everything. Your job shouldn't become a vulnerability, but staying organized is the best way to prevent surprises. Because sometimes it's not enforcement at the border, it's enforcement at the office. Have you ever checked your work documents recently? Drop a comment and let us know. Your story might remind someone else to double check theirs. We invest serious time researching and simplifying these updates for you. So please take just one click to subscribe. That single click helps us keep bringing you critical information that truly matters. Number 5, green card holders are not automatically safe. Here's a belief that shocks many people. Having a green card does not guarantee permanent safety from deportation. In 2026, updated enforcement priorities and stricter case reviews are putting lawful permanent residents under closer examination than many expected. A green card gives you the right to live and work in the United States permanently, but it comes with conditions. Certain criminal convictions, extended trips outside the country, fraud findings, or even failure to properly maintain residency requirements can still trigger removal proceedings. What's changing now is the level of scrutiny. Immigration officers are reviewing past records more carefully during renewals, re-entry screenings at airports, and citizenship applications. That means something that happened years ago, even decades ago, could resurface during a routine process. Imagine living in California for 15 or 20 years, building a family, owning a home, paying taxes, and then facing tough questions during a green card renewal because of an old legal issue you thought was behind you. It's not common for most people, but it's not impossible either. Another overlooked risk? Long trips abroad. If a permanent resident spends extended time outside the US without proper documentation, authorities may question whether they abandoned residency. So, what can you do? First, review your full legal history, even old cases. Second, limit extended international travel unless you've consulted an attorney. Third, if you're eligible for citizenship, only consider whether naturalization may offer stronger long term security. In 2026, permanent doesn't mean untouchable. It means protected, but only if you stay informed and proactive. Did you think green card holders were completely safe? Be honest. Tell us in the comments. Your perspective might open someone else's eyes. We dedicate serious effort to researching and simplifying these complex topics, so please take just 1 second to hit subscribe. That one click helps us keep protecting and informing this community. Number 6, stricter fraud detection. In 2026, immigration authorities are placing a stronger spotlight on fraud detection and documentation accuracy. And here's the part that worries many families. Fraud doesn't always mean intentional deception. Sometimes it's simply an inconsistency, missing evidence, or information that doesn't perfectly match across forms. Marriage-based petitions, asylum applications, employment sponsorships, these cases are now being reviewed with much deeper scrutiny. Officers are cross-checking records, comparing past applications, reviewing social media, and verifying timelines more carefully than before. Imagine submitting paperwork years ago with a small mistake, maybe a wrong date, a different address format, or a misunderstanding during translation. At the time, it didn't seem serious, but during a renewal or adjustment of status in 2026, that inconsistency could trigger additional questioning. The key word here is consistency. Even small discrepancies between old and new forms can raise concerns, and once a fraud investigation begins, cases can be delayed for months or even denied. Another growing issue is relying on unqualified immigration consultants or notarios who fill out forms incorrectly. Applicants often assume everything was done properly until they discover critical errors later. So, what should you do? First, keep copies of every immigration document you've ever submitted. Second, review old applications before filing new ones to ensure all information matches. Third, work only with licensed immigration attorneys or accredited representatives. In 2026, paperwork is more than paperwork. It's your record, your credibility, and in many cases, your future. Precision matters now more than ever. Have you ever double checked your old immigration forms? Share your experience below. Your comment could save someone from a costly mistake. We put real time, research, and care into every video, so please take 1 quick second to subscribe. That single click helps us continue bringing you clear and powerful updates. Number 7, public benefits reviews. Here's something many families don't realize. Certain public benefits and assistance programs can sometimes raise immigration questions, depending on your status and the type of benefit received. And in 2026, eligibility reviews and documentation checks are becoming more detailed. Now, let's be clear. California offers many state-level protections and programs that are designed to help residents regardless of immigration status. But federal agencies may still evaluate benefit usage differently when reviewing visa extensions, green card applications, or adjustment of status cases. The issue isn't simply receiving help, it's how that help is classified. Some federal programs require income verification, residency proof, or sponsor information. During future immigration reviews, officers may examine whether applicants met eligibility rules correctly at the time they applied. If there were misunderstandings or if someone applied based on incorrect advice, it could lead to deeper questioning later. Imagine applying for assistance during a difficult financial period, believing everything was done properly. Years later, during a status review, you're asked to explain documentation details you barely remember submitting. This doesn't mean people should avoid necessary help out of fear. It means they should apply carefully and correctly. So, what's the smart move? First, confirm which benefits are considered safe under your specific immigration category. Second, keep organized records of approvals and eligibility letters. Third, consult an immigration professional before applying if you're unsure. In 2026, but transparency matters. Receiving support isn't the problem. Misunderstanding the rules can be. And clarity today can prevent complications tomorrow. Have you or someone you know ever felt confused about benefit rules? Share your thoughts below. Your story could guide someone else. We put serious effort into researching these updates for you. So please take just one click to subscribe. That small action helps us keep delivering information that truly makes a difference. Number 8. Old criminal records are being re-examined. Here's something that's catching many long-time residents off guard in 2026. Old criminal records are being reviewed again under updated enforcement priorities. And for some people, that past they thought was closed and forgotten is suddenly back in focus. Years ago, certain minor convictions may not have triggered immigration action. Policies were different, enforcement priorities were different. But today, digital record systems make it easier than ever for agencies to access decades old information within seconds. Imagine resolving a case in your early 20s, paying a fine, completing probation, moving forward with your life. You build a career, you raise a family, you stay out of trouble. Then, during a green card renewal or citizenship interview, that same old case is flagged for review. That's the reality many legal experts are warning about. Another important point: expungement does not always erase immigration consequences. In criminal court, a case may be dismissed or sealed, but immigration law operates under a different standard. Federal authorities may still consider the original conviction when evaluating status. The key word here is re-evaluation. This doesn't mean everyone with a past issue is suddenly at risk, but it does mean assumptions are dangerous. What was considered low priority before may now receive more attention. So, what can you do? First, obtain a full copy of your criminal record, not just what you remember. Second, have an immigration attorney review any past convictions, even minor ones. Third, I explore whether post conviction relief options exist if needed. In 2026, preparation beats surprise because sometimes the biggest risk isn't what's happening today, it's what happened years ago. Have you ever checked your full record? Or are you relying on memory? Be honest in the comments. Your answer might encourage someone else to take action. We invest real time and effort into breaking this down clearly. So please take just 1 second to hit subscribe. That single click keeps this information flowing to those who need it most. Number 9. Targeted enforcement in certain counties. Here's something many people don't talk about enough. Where you live in California can influence how immigration enforcement plays out. Even though California maintains sanctuary style protections at the state level, federal authorities still operate independently, and enforcement patterns can vary from county to county. In 2026, Analysts are noticing more targeted operations in specific areas based on federal priorities, criminal data, and local cooperation nuances. That means two families with similar situations could face very different experiences depending on their county. Imagine living in one area where local law enforcement limits cooperation with federal immigration authorities. Now compare that to another county where certain information sharing practices are more active. And the policies might look similar on paper, but the practical outcomes can feel very different. Another factor? Population density and prior enforcement data. Federal agencies often focus resources where they believe violations are more concentrated. This doesn't mean random mass action, it means strategic prioritization. The important word here is awareness. Many people assume statewide laws guarantee identical experiences everywhere. But immigration enforcement operates on multiple layers: federal, state, and local. Understanding your county's approach can help you make informed decisions about legal consultations, documentation reviews, and travel. So, what can you do? First, research your county's cooperation policies. Second, stay connected with reputable local immigrant advocacy organizations. Third, don't rely on rumors, rely on verified information. In 2026, geography isn't just about where you live, it could influence how policies are applied around you. Do you know how your county handles immigration cooperation? Drop your county name in the comments. Let's learn from each other. We spend serious time researching these details for you, so please take one quick click to subscribe. That simple click helps us continue delivering updates that truly matter. Number 10. Appeals and relief are becoming more complex. Here's the final and possibly most important reason. These 2026 changes matter. The appeals and relief process is getting more complicated. And when rules become more complex, the margin for error becomes smaller. Immigration courts are facing heavy backlogs. Cases can take months or even years to resolve. But during that waiting period, deadlines still apply. Forms must be filed correctly. Evidence must be submitted on time. One missed notice, one outdated address, or one incomplete document can seriously affect the outcome. Imagine receiving a court notice in the mail, but you recently moved and forgot to update your address. If you miss your hearing, you could receive an automatic removal order without ever explaining your case. That's not drama. That's reality for many people navigating the system alone. Another major issue in 2026 is the shifting interpretation of relief options. Programs, waivers, asylum claims, cancellation of removal, these pathways still exist. But eligibility reviews are tighter, documentation standards are higher, and preparation matters more than ever. The key word here is precision. This is no longer a system where guesswork works. Small errors that once might have been corrected informally are now more likely to cause delays or denials. So, what's the smartest move? If you are ever placed in proceedings, act immediately. Update your contact information. Keep copies of every notice. Seek qualified legal help early, not after a deadline passes. In 2026, your defense isn't just your eligibility, it's your preparation. And when the stakes are this high, the preparation can make all the difference. If this series opened your eyes, tell us in the comments. Which of these 10 reasons surprised you the most? We genuinely read your thoughts. They guide our next videos. We put tremendous effort into researching and breaking this down clearly for you. So please take just 1 second to hit subscribe. It's one simple click for you. but it helps us continue protecting and informing this community. It's not panic, it's not fear, it's preparation. The immigration landscape in California isn't changing overnight into something unrecognizable, but it is becoming more detailed, more data driven, and far less forgiving when it comes to mistakes. Expanded data sharing, stricter offense classifications, increased visa monitoring, workplace audits, deeper fraud reviews, benefit evaluations, old record re examinations, county level enforcement differences, and more complex appeals. All of these changes point to one thing: scrutiny is increasing. And scrutiny means responsibility. For undocumented individuals, visa holders, green card holders, and even long-time residents, the margin for error is shrinking. Small issues that once seemed minor can now carry larger consequences. But here's the empowering truth: knowledge gives you control. Where when you review your documents early, consult professionals when needed, keep records organized, and stay informed about policy shifts, you dramatically reduce your risk. Most immigration problems don't appear out of nowhere. They build quietly over time due to misunderstandings, delays, or assumptions. Ask yourself honestly: if your case were reviewed tomorrow, would everything be in order? If the answer is uncertain, that's not a reason to panic. It's a reason to act. Because in 2026, the people who stay protected won't be the lucky ones. They'll be the prepared ones. Stay informed, stay organized, stay proactive. Your future is too important to leave to chance.